Hey, good evening, everyone. Today's July 1st, and in keeping with the theme around the birthday of the nation and such, I'm going to cover sort of a political topic, but it's a topic that should be important to anyone that hunts, or anyone that's into outdoors, or anyone that's really into freedom. I'm going to talk about the recent laws that have been passed in Virginia and their gun ban. I'm also going to discuss the Bruin decision and why one Supreme Court case changed everything. Now, nothing in this four-part series should be considered legal advice. If you need legal advice, you need to talk to an attorney because that's the only person that can give you actual legal advice. I'm a trained analyst and I've read the information and I'm going to give you my analytical opinion. And a free opinion's worth what you pay for it, right? So here we go. I'm Todd Edwards and welcome back to Tick Bite NC. If this is your first time joining us, welcome aboard. We're here to talk about hunting, fishing, local history, the outdoors, constitutional issues like tonight, and sometimes the stories that affect every one of us, whether you realize it or not. This episode will be one of four. Now, before we get started, let me say something right up front. This is not a political rally. It's not an endorsement of one party or another, and it's not an attack on anyone. Tonight, we're going to do something that's been sharply rare in today's world. We're going to slow it down. We're going to read what the law actually says, and we're going to look at what the courts have ruled. And we're going to explain why one Supreme Court case from 2022 has completely changed the way gun laws are judged in America. Whether you own one gun or 100, whether you hunt every Saturday, or whether you've never fired a gun in your life, what happens in these cases affects every American because it's ultimately a story about how constitutional rights are interpreted. And if you followed this channel for very long, you'll know that's something I care deeply about. It's not because it's guns, it's because it's about our Constitution, the very document that our country was founded on, and the document that I raised my right hand and swore to give my life to defend. Now, there's a state, technically it's a commonwealth, that suddenly found itself in the national spotlight. That's Virginia. But for years, when people talked about restrictive gun laws, they usually mentioned California, maybe New York, New Jersey, Massachusetts, or Illinois. Virginia was not the first state that came to mind. That changed this year. After the elections, Virginia's government passed one of the largest firearms legislation packages in the state's history. Supporters call it common sense gun safety. Opponents called it one of the broadest firearms bans ever attempted by the Commonwealth. And almost immediately, the lawsuits were filed. Not weeks later, not months later, almost immediately. And just days before the law was scheduled to take effect, a Virginia judge temporarily stopped one of its most significant provisions while the courts sorted out whether it's constitutional. And that's an extraordinary sequence of events. But before we can understand why the courts intervened, we must first have to understand what Virginia actually passed, because on that, there has been a lot of confusion. The headline didn't tell the whole story. The headline usually never does. Most news headlines simply call it an assault weapons ban. That's accurate, but it's also incomplete. While most people hear those words, they picture one rifle, usually an AR-15, maybe an AK style rifle. That's understandable. Those rifles are shown on TV every time this issue comes up. But that's not actually how Virginia's law works. The law doesn't simply say AR-15s are banned. Instead, it creates a legal definition of what Virginia calls an assault firearm. That definition is based on characteristics. Lawmakers listed combinations of features, things like detachable magazines, pistol grips, threaded barrels, adjustable stocks, flash suppressors, forward grips, certain automatic operating systems, certain semi automatic operating systems. And whether enough of those characteristics exist together, the firearm falls within the statutory definition. Now, I want you to think on that for a minute. It's not one manufacturer, it's not the model, it's a legal classification. And classifications matter because once government creates a category, everything inside that category can be regulated in the same way, whether you agree with the law or not. Understanding that distinction is important. Now, I want to ask you a question. Does your hunting rifle have a detachable magazine? Does it have a forward grip? Think about these things. It's also more than rifles. One of the biggest misconceptions I've seen online is this law only applies to rifles. It wasn't. The legislation also reaches certain semi-automatic pistols, certain semi-automatic shotguns, and there comes another issue that many gun owners probably care about more: magazines. Virginia drew the line at 15 rounds. If the law ultimately survives constitutional review, future sales and many transfers of magazines capable of holding more than 15 rounds would be prohibited under the legislation. Notice something important. The law isn't regulating how many rounds you fire. It's regulating the magazine itself. Supporters argue those magazines increase casualties during mass shootings. Opponents respond that millions of these magazines are factory standard equipment and sold with common handguns and rifles across the country. That disagreement is now sitting squarely before the courts. They're coming to take your guns. Let's address another rumor. No, Virginia did not pass a law ordering police to go door to door confiscating firearms that people already legally own. That's one of those claims that spread quickly online, but it doesn't match the text of the law. Generally speaking, people who already possessed covered firearms before the law's effective date could continue to possess them subject to the law's terms. The law focused primarily on future commerce, future sales, future purchases, future imports, future transfers. Why does this matter? Because lawmakers understood something. Confiscation would almost certainly create immediate constitutional problems and enormous practical challenges. They also probably realized that people weren't going to just hand them over. Instead, the legislation attempts to reduce the future availability of covered firearms while largely grandfathering existing owners. Whether that's constitutional is exactly what the courts are now deciding. Why hunters and outdoorsmen should not shrug this off. Now, I already know there's some folks thinking, man, I hunt deer with a 30-30. I got a bolt action 270. I carry a shotgun for ducks. This doesn't affect me. Maybe, maybe not. Because constitutional cases rarely stay confined to one type of firearm. Think about every constitutional right. When courts interpret the First Amendment, they're not deciding one newspaper case. They're setting precedent that applies to future speech cases. The same thing happens with the Second Amendment. Today's ruling on semi-automatic rifles may become tomorrow's precedent involving handguns, or shotguns, or carrying firearms. Maybe it's ammunition or magazines. That's why the lawyers on both sides understand this case is bigger than one rifle, and it's bigger than Virginia. It's about constitutional methodology. It's about how judges decide these questions in the first place. Why this case is different. If Virginia had passed this exact same legislation 15 years ago, there's a decent chance much of it would have been upheld. And that surprises a lot of people. They assume the Constitution hasn't changed, and they're right. The Constitution has not changed. But what did change? There was a legal test used by the courts, and that brings us to one Supreme Court case that every gun owner, every hunter, and every constitutional law student, and frankly, every American should understand. It's a case called New York State Rifle and Pistol Association versus Bruin. Now, if you've heard people mention the Bruin decision online, you may have wondered what's all the fuss is about. Why does one court case keep coming up every time somebody files a lawsuit over a gun law? Why are attorneys talking about the history books from the 1700s? And why are judges asking what people did in 1791? After all, this is the 21st century and it's 2026. But once you understand what happened in Bruin, you'll understand why Virginia's new law ran into legal trouble almost immediately. Because Bruin didn't just decide one dispute in New York, it fundamentally changed the rules that every court in America now uses when deciding Second Amendment cases. And that's exactly where we're going next. Thank you for watching part 1. Tune in tomorrow night as I explore part 2, the case that changed everything.